Case 74, Wallace versus Korean Air. Warning: sexually explicit content. We find ourselves in the U.S. Court of Appeals for the Second Circuit. Facts. On the evening of August 17, 1997, Brandy Wallace boarded Korean Airlines Flight 61 in Seoul, Korea, destination Los Angeles, California. It being the middle of summer, Miss Wallace wore a t-shirt and jean shorts with a belt. Initially, the flight passed uneventfully. Miss Wallace was seated in a window seat in economy class and fell asleep shortly after finishing her in-flight meal. Two male passengers sat between Miss Wallace's window seats and the aisle of the airliner's cabin. Seated closest to Miss Wallace was Mr. Kwang-young Park. Before she fell asleep, Miss Wallace had neither spoken to Mr. Park nor given him the slightest indication that familiarity would be welcome. Nevertheless, about 3 hours into the flight, Miss Wallace awoke in the darkened plane to find that Mr. Park had unbuckled her belt, unzipped and unbuttoned her jean shorts, and placed his hands into her underpants to fondle her. Miss Wallace woke with a start and immediately turned her body toward the window, causing Mr. Park to withdraw his hands. When Mr. Park resumed his unwelcome amours, however, Miss Wallace recovered from her shock and hit him hard. She then climbed out of her chair and jumped over the sleeping man in the aisle seat to make her escape. At the back of the plane, Miss Wallace found a flight attendant and complained about the assault. The attendant reassigned her to another seat. When the plane arrived in Los Angeles, Miss Wallace told airport police about the incident, and they arrested Mr. Park. He subsequently pled guilty in the United States District Court for the Central District of California to the crime of engaging in unwelcome sexual conduct with another person, in violation of 18 U.S. Code 2244. In February 1998, Wallace brought this action against Korean Airlines in the United States District Court for the Southern District of New York, alleging that Korean Airlines was liable for Park's sexual assault under the Warsaw Convention, which applies to all international transportation of persons, baggage, or goods performed by aircraft for hire. As modified by the Montreal Agreement, the Warsaw Convention makes airlines liable if the accident which caused the damage so sustained took place on board the aircraft or in the course of any of the operations of embarking or disembarking from an international air flight. Following discovery, Wallace moved for summary judgment on her Warsaw Convention claim. The district court denied the motion and dismissed that claim. Relying on its reading of Air France versus Sachs, the district court reasoned that because the sexual assault was not a risk characteristic of air travel, it therefore did not constitute an accident for purpose of the Warsaw Convention. Wallace now appeals. Issue: whether Mr. Park's assault of Miss Wallace constituted an accident under Article 17 of the Convention. Holding: the appellate court held that the district court's decision that Mr. Park's assault of Miss Wallace did not constitute an accident under 17 of the Convention is vacated, and this case is remanded for further proceedings. The court expressed no opinion on any other aspect of Miss Wallace's Warsaw Convention claim. The Warsaw Convention had two goals. Number 1, to establish uniform rules for international air travel, and 2, to limit potential carrier liability for passenger injuries so as not to frighten away potential investors from the fledgling air industry. To achieve these goals, the convention capped the airline's potential liability to each passenger at 125,000 gold French francs, or approximately $8,300. At the same time, however, the convention made the airlines subject to Article 17, which provides in its entirety: the carrier shall be liable for damage sustained in the event of the death or wounding of a passenger or any other bodily injury suffered by a passenger if the accident which caused the damage so sustained took place on board the aircraft or in the course of any of the operations of embarking or disembarking. Article 17 created what the courts have characterized as a presumption that air carriers are liable for passenger injuries. There was a counterweight to the presumption. Carriers could avoid Article 17 liability altogether by establishing the so-called due care defense provided by Article 20. The carrier shall not be liable if he proves that he and his agents have taken all necessary measures to avoid the damage, or that it was impossible for him or them to take such measures. Although the Convention itself does not define an accident, the Supreme Court addressed the meaning of that term in Air France versus Sachs. In addressing what constitutes an accident, the Supreme Court essentially adopted the Third Circuit's language, defining the term as an injury caused by an unexpected or unusual event or happening that is external to the passenger. The Court announced that this definition should be flexibly applied, and as examples cited with approval to lower courts in this country that have interpreted Article 17 broadly enough to encompass torts committed by terrorists or fellow passengers. The Court noted that with respect to the particular facts that gave rise to an accident in this case, it was plain that the characteristics of air travel increased Miss Wallace's vulnerability to Mr. Park's assault. When Miss Wallace took her seat in economy class on the Korean Airlines flight, she was cramped into a confined space besides two men she did not know, one of whom turned out to be a sexual predator. The lights were turned down and the sexual predator was left unsupervised in the dark. It was then that the attack occurred. Equally important was the manner in which Mr. Park was able to carry out his assault. While Miss Wallace lay sleeping, Mr. Park, number 1, unbuckled her belt, 2, unbuttoned her shorts, 3, unzipped her shorts, and 4, squeezed his hands into her underpants. These could not have been 5-second procedures even for the nimblest of fingers. Nor could they have been entirely inconspicuous, yet it was undisputed that for the entire duration of Mr. Park's attack, not a single flight attendant noticed the problem. And it is not without significance that when Miss Wallace woke up, she could not get away immediately, but had to endure another of Mr. Park's advances before clambering out to the aisle. In sum, recognizing the flexibility called for by Sachs, the Court was satisfied that Mr. Park's assault on Miss Wallace was, in the language of Sachs, an unexpected or unusual event or happening that was external to the passenger. As such, it constituted an accident for purposes of Article 17 of the Warsaw Convention.